Whenever you're ready.
Good morning, Your Honors. Courtney Orr on behalf of the state. I would like to reserve 3 minutes for rebuttal.
Okay.
Your Honor, we are here today from an order of the trial court dismissing the state's indictment with prejudice after finding essentially that the defendant's right to a speedy trial was violated. The trial court's order was in error. To just give a brief factual recitation of the timeline of this case, the defendant was arrested in May of 2022. And then in September of 2022, the grand jury returned an indictment charging him with especially aggravated kidnapping, aggravated rape, and 3 counts of aggravated assault for offenses committed against who I believe was his romantic partner. There was a delay for about 6 or 7 months when, in April of 2023, the rape kits were returned to the state from the TBI, which they had sent for testing. And then the initial trial was set in September of 2023. A few days before that trial setting, about 2 days, the state informed the trial court that it was having trouble locating the witness, that they understood from her daughter she was refusing to come to court because she had pending charges, unrelated charges in another county. And the court gave the state a few days to find the witness, but then in that September trial setting, they were still unable to contact her, and they asked that the case be reset for trial. It was reset. The defendant's bond was reduced, and the state continued to look for this witness. A few days after that resetting date, the state moved for a material witness bond to secure that witness's presence at trial. And then in the pendency between the first trial setting and the second trial setting, the state was able to resolve the unrelated charges against the witness. She was ordered to drug court for those misdemeanor charges, and as a condition of dropping the material witness bond, it was ordered to report to drug court weekly and to report to the DA's office weekly to make sure that they could stay in touch with her prior to trial. The victim or the witness complied with those reporting requirements until about 2 weeks before the January trial setting. 2 weeks before that January date, the state again lost track of the witness and could not find her. And then they came to court that day and said, we have lost track of her, we're trying to find her, but we do need to reset this again. The case was then reset for May of 2024 in the pendency of that, or between January and May, 2023, I believe. I apologize, 24. Okay. Between January and May of 24, the defendant filed a speedy trial motion. And then in May of 2024, the final setting of this case, the state came, they said, we have been unable to find the victim. We would like to nollie these charges. And at that point, the court said, you have made a valiant effort to find this witness, but you cannot move forward without her, and dismissed the case with prejudice. Simply put, the trial court did not engage in any of the analysis required under Barker versus Wingo to establish there was a speedy trial violation, and the record shows that there was no speedy trial violation in this case. We're here under a de novo standard review, so I'll go through each of the 4 factors. The length of the delay. We admit that the Barker analysis is triggered after 1 year, and this was about a 20-month delay between the indictment and the final setting where this case was dismissed. 20 months triggers that the Barker analysis. However, it is by no means an excessive delay here. I'll note that at least the first 6 months of this delay between the indictment and the trial setting was because the state was waiting on testing results from the TBI. And this is a very serious case involving 5 different serious felonies, and that investigation required that amount of time. So a 20-month delay for 5 serious felony cases is not excessive. And second, the reason for the delay should not weigh against the state here. This delay falls squarely within delay that is necessary for the fair and effective prosecution of the case. As I mentioned, at least 6 months of this delay was to allow the state to obtain testing it had sent for the TBI. And then everything after that was the state trying valiantly, in the trial court's words, to locate and secure a material witness for trial and being unable to do so.
So
Yeah.
when the victim witness was released, was that with the agreement of the state, or did the court unilaterally do it?
I'm sorry, Your Honor?
Did the state agree to the witness entering drug court
Yes, I believe so.
and reporting to them, correct?
Yes, Your Honor.
So how is that not imputed to the state?
It is a effort of the state to secure this witness, but it does not show negligence that would weigh heavily against the state. The state was actively trying to find this witness and actively making sure that they kept in touch with her and had her available for trial. Indeed, she was in touch with the state until 2 weeks before the trial was set. And there was nothing at the time that the state agreed to this release for them to indicate that she would have been a flight risk without, more stringent reporting requirements, or I believe at some point in the briefing, defense suggests that she needed to be incarcerated.
Well, they actually got a warrant for her, though, didn't they?
They did, but because that time, their understanding and all the information available to the state was that she was fleeing because she was trying to evade these pending charges. But those pending charges were resolved in what ended up with her in drug court. There was no other information that she was going to continue being a flight risk or unable to be found after those pending charges were resolved. And indeed, the evidence showed that she was continuing to cooperate. She entered drug court. She came to drug court weekly. She reported to the DA's office weekly. There was nothing for the state to indicate that they needed to continue this material witness bond, that they needed to oppose alternative sentencing that she was apparently a candidate for, and the state showed no negligence in trying to secure this witness for trial and was doing everything that it could within reason to secure her presence. And until the 2 weeks before the trial setting, it appeared that was successful. So the record shows that the reason for this delay was not because of the state's negligence. It was not any intentional delay, but it was necessary delay to ensure the fair prosecution of this case, which should not be weighed against either party. And for the third factor, the defendant did invoke his right to a speedy trial. That does weigh in the defendant's favor. However, I'll note that this was at first an oral motion for a speedy trial. The trial court had to instruct this defendant to file that written motion. The written motion was not filed until March of 2024, about 2 months before the case was ultimately dismissed, but that factor does weigh slightly in the defendant's favor. But the most important factor here in the the factor that weighs heavily against the defendant is that the defendant has not shown any prejudice from this delay. As I said, the delay of 2 years is not extreme. The defendant has identified no witnesses or proof that became unavailable because of the delay. He references one witness that he believes would have impeached the victim's testimony, but that witness is not identified in the record other than an unnamed witness. And he claims he was unable to find the witness a few weeks before I believe it was the May trial setting. I'll defer to the record on which trial setting it was before, but he was unable to find that witness a couple weeks before, but he had been in touch with that witness up until that point and had been subpoenaing this witness for trial. And there's absolutely no indication that his inability to find the witness in that 2-week period was because of this delay at all. And further, the defendant claims this adverse mental health effects from his incarceration or just having charges pending against him. I will note that throughout the process of this case, as it kept getting delayed, this trial court initially was reducing the defendant's bond and then eventually released the defendant with a GPS monitor and granted the defendant the extraordinary relief of being able to cross state lines with that GPS monitor so that he could get to work in order to reduce this detrimental mental health effect and detrimental effects of on his life that came from the delays from this trial. And further, as the Supreme Court has noted in Moon, that absent any unusual showing, anxiety and concern about pending charges are not determinative of proof of their own that there is prejudice that results from a pretrial delay. Simply put here, the defendant has only shown that there was one witness that he has not told us who it was or what that witness would say that he couldn't find, maybe because he's lost track of him, but it's not indicated that it's because of this delay. And there's simply no extraordinary mental health or effects on his life that would show prejudice. And the defendant cannot show that he suffered prejudice from this 20-month delay between indictment and dismissal.
Let me take you back a little bit. Can you, the timeline as far as when proceedings started, date-wise, when he made this oral motion for speedy trial, when he filed the actual written motion, and then the hearing?
With the caveat that I did not write this
I
brief, Your Honors.
understand. I understand.
I believe, and I will defer to the record in this, I believe the oral motion for speedy trial was made in the September 2023 setting.
Yeah.
And my friend on the other side may have a better grasp of that. And then in January of 2024, the court asked the defendant to file a written speedy trial motion. And then the speedy trial motion, the written motion was filed on March 22nd of 2024, and the case was ultimately dismissed on May 13th of 2024.
Okay. All right. Thank you for that.
Unless there are any further questions, I will reserve my 3 minutes for rebuttal.
Thank you.
Morning, Your Honors. Kendall Jones from the Appellate Division on behalf of the appellee, Mr. Mason. We're here today, and I have raised a housekeeping issue that I don't normally raise, but I think it's significant enough in this case that it needs to be addressed. There's only one real issue from what I can tell that the state has raised an appeal, and that's with the speedy trial motion. I have also addressed in the brief real concerns that I have with the validity and the accuracy of the record. And I don't like to nitpick and get into the record, but it's necessary in this case.
Okay.
So I alluded to in my brief that there are several items that should not have been included in the record. Most specifically, and the state rightly points out that I misunderstood why they're there, and it's in fact, upon review, worse than what I thought. So under this, we're under Trap 24, the contents of the record, which state under Section A that certain items are to be included, including any papers that are filed in the trial court, as relevant here, and exhibits that are filed within the trial court. And then in Section G, it also says that nothing in the record shall be added or subtracted unless it's something that is necessary to convey a full, accurate, and complete record of what happened in the trial court. Now, the problem here, at its very most basic, we have 3 transcripts in the record. All 3 of the transcripts from the 3 different trial settings on page 4 of each of them say no exhibits were entered by the state. And yet we have a volume 5 that includes 5 exhibits. Now, I presume that I have no idea how they were not made exhibits at any of these proceedings and then listed and included as exhibits in volume 5. If they were filed as part of the trial court file, they would have been included in the technical record. And if that was the case, at worst, it would be their items that are discovery items that should not be included in the record if they were filed in the trial court. And the problem goes a little bit deeper than that. The record in this case was defected by this court twice, and the second time, Judge Greenholz wrote an order outlining the defect problems and then ordering the trial court clerk to file the record. And one of the things that Judge Greenholz mentioned in his order were that there were no certificate of certification, no chronological ordering of the filings, no timestamps on several of the other items, and there was no indication that the motion to reconsider that the state filed was ever heard by the trial court. Meaning, if it was not heard by the trial court under G, it was not properly includable as something that was what transpired in the trial court. Now, the state has argued in its reply brief that it seems to, that because it was filed, it deserves to be in the record, and that's not the case here. If the judge did not adjudicate or do anything with the motion, then it doesn't need to be includable. It does not need to be included in the record. The exhibits in and of themselves are problematic, and I hate to get in the weeds, but I need to on this one. The 5 exhibits that are included are the state's motion to reconsider as Exhibit 5. Exhibit 1 is an exhibit from the General Sessions Court. It doesn't appear that it was ever made part of the trial court record or filed in the trial court record. Now, it's time-stamped Melissa Jenkins, Circuit Court Clerk, but as we all know, Circuit Court Clerk is responsible for keeping the files of both General Sessions and the Circuit Court Clerk. It even says on the front cover sheet for the exhibit from General Sessions Court. So it appears that it was never made an exhibit in the trial court here, which the facts bear out because none of the transcripts indicate that the state tendered any exhibits, and they're pictures of the alleged victim while she's sitting in a hospital bed. So even at that point, even if they were filed and should have been something maybe considered for the technical record, those are matters that would have been discoverable. Probably the most interesting ones are 3 and 4. The state filed on July 28th of 2023, which is in Volume 1, page 31 of the technical record, a notice of intent to introduce medical records, and that was before the first trial setting. The Circuit Court Clerk file stamped all of the medical records with an affidavit from the records keeper from Tenova and expert reports from the TBI. They are time-stamped on 8/31/23. The Tenova affidavit, which is file-stamped 8/21/23, is noted that it is notarized on September 25th, 23. So the clerk has put a file stamp on these that would not have been possible if they were notarized a month later. I don't know if they were alarmed about the fact that they didn't have some timestamps and just put their best guess on it, but that's not, unless there's a rip in the space-time continuum in the Circuit Court Clerk's office in Polk County, that's not possible. And the same thing is true with Exhibit 6. There's an invoice in Exhibit 3 from one of the hospitals for bringing in the medical records. It's file stamped from the Circuit Court Clerk's office 8/21/23. The invoice is dated 9/28/23. Exhibit 4, affidavit of custodian from Erlanger Health Systems. It's not file stamped, but the cover sheet that the judge signed off on says it was filed on 8/21/23. The notary is from August 30th, 9 days later on 2023. So even if the court should find by some miracle that these exhibits, which were never tendered at any of the transcripts that the state has provided, the timestamps that are on them bring serious question as to when these actually were filed with the court or if they were even considered by the court. For that reason, we've raised the first issue before we got to the speedy trial, that these need to be something that this court does not look at in terms of the record. As to the speed, if the court has no further questions, I'll stop belaboring the details of the record. I think in these cases, when they say 20 months, now to the state's point about the TBI records, we don't get to a speedy trial motion unless we approach a year, and those were before the year. That's absolutely fine that it was something that they were not able to get for that time. The indictment, the original arrest occurred in May of 2022. Mr. Mason was in custody without a cell phone, without access to money, without access to anything in his life that he's going to be, his house, whatever he rented. When we say 20 months and that's not a prejudice, we have to look at this as if we were in jail for 20 months. And it's easy to say that it's not egregious or prejudice because these are serious charges. But it's a difficult thing to sit with a client in jail and explain to him why he has to keep sitting in jail when the victim's deciding not to show up to prosecute. Now, the state has raised a couple of points We are under a mixed question of fact and law here. The trial court's findings are given abuse of discretion, and then the review of those application to the law is de novo. And the four factors for Barker versus Wingo, we've got the length of delay, the reason for delay, whether or not a motion was filed, and the prejudice to Mr. Mason. Mr. Mason, and I'll point to one of the cases that I cited to in my brief, Doggett versus United States. The state has indicated that we cannot show the fourth factor, the prejudice. And I think this case is very poignant in its statement that consideration of prejudice is not limited, this is on page 31 of my response brief, not limited to the specifically demonstrable and affirmative proof, and it is not essential to every speedy trial claim. Prosecutorial negligence is not automatically tolerable simply because the accused cannot demonstrate exactly how it has prejudiced him. Instead, courts generally have to recognize that excessive delay presumptively compromises the reliability of a trial in ways that neither party can prove, for that matter, identify and include this in their assessment of the speedy trial claim. Noting that Barker versus Wingo, Moore versus Arizona also noted that Barker versus Wingo expressly rejected the notion that an affirmative demonstration of prejudice was necessary to prove the denial of a constitutional right to speedy trial. Mr. Mason indicated to the court and represented to the court that he'd had a witness that he had twice summoned to be there to counter the alleged victim's claims. This is essentially at the core of it a he said, she said case where everything is going to return on the reliability of or the credibility of the witnesses who are testifying. And in this case, I don't presume to know what's going on with the alleged victim's life or why she didn't show up. But the fact remains that at the first setting, she lied to the state and she lied to the prosecuting officer and told them both that she would be there and then didn't show. I understand she may have had warrants present and that was a factor, but they gave her a material witness bond. They got her out of jail. She was given the benefit of released on her own recognizance after not showing up, which was not given to Mr. Mason until January, 20 months in. He was able to get out on a $1,000 bond, a tracking device, and reporting to a probation officer despite the fact that he was not on probation. The trial court mentioned all of these in its recounting of the history at the end of the hearing in May of 2024 when it was finally dismissed. The alleged victim was given the opportunity to go to drug court, did not show. The state indicated at the January hearing that as much as 2 weeks before that hearing, they knew she had stopped reporting to drug court and didn't do anything, and with no bonding agent or tracking officer, they had a person who had not only not shown up for court in General Sessions Court, but not answered to her subpoena for trial, and then lied about going, the fact that she was going to be there to them.
But 2 weeks before trial doesn't seem, outrageous that they knew 2 weeks before trial and didn't do anything. I mean, they could have filed something. I don't know when they filed a motion to continue, but I mean.
The court had the foresight to set status hearings before the trial so that they didn't call a jury panel in and inconvenience them. But I think in this case it was abundantly necessary for someone who had proven that they had deliberately and actively, intentionally not showed up. If this was a defendant who had done this, this would be a different conversation we would be having.
It's also a different situation if it's a defendant versus a witness, though. I mean, like a second ago, you said, she was given an ROR bond and attended drug court. I mean, they're also charged with different crimes, too. I mean, she clearly if she's going to drug court, she had a drug offense. He's charged with kidnapping and some other more serious crimes. So the fact that they're treated differently, ROR versus a bond or versus an anklet, that's really not, you're comparing apples and oranges there.
And I disagree. We have a man who's been charged with serious crimes. We also have a man who's been in custody for 20 months, over a year. And because of this person who has been charged with misdemeanor offenses, who does not honor her obligations to show up to court, either for her own charges or to finally answer to the person that she's accused of doing all these horrible things. I don't think it's really a question of, well, she was charged with lighter things and he was charged with more serious things. I mean, he showed up even after he was given an anklet ROR. Like, he did not do anything to violate the court's trust. The alleged victim here repeatedly excused herself, so it's not really an issue of it's worse that you don't show up to court if it's a misdemeanor versus a felony. She didn't show up. It's disrespectful to the court either way, and it's disrespectful to a man who's been incarcerated because of her allegations all that time. All that time that she does not show. And I don't know why she didn't show. She may have stuff going on, but I can't excuse, or we can't excuse, and the judge didn't excuse the fact that you have a victim who has reported a crime and 2 years later is no longer interested in prosecuting it and no longer interested in speaking with the state.
Well, I want you to go into some more. I want to hear more about how he's prejudiced by the null pros and potential or not of them coming back with charges they can never figure it out with the victim.
Well, the prejudice here, if you read the record at the January hearing, he suggested an all pros, and that was dismissed outright by the state. So he suggested an all pros, and that's the point when the trial court asked about the speedy trial motion and then told the attorney for Mr. Mason to go ahead and file one. And he did 2 months later. The state did not respond to that motion until the day, or file their response to that motion until the day of that hearing. And the trial court told the state as early as the September hearing, these are serious charges, you need to get your witness here. And if a witness doesn't show at the first time at either the General Sessions Court where she's got charges or for trial, that means that you have a problem and you need to have not only the supervision, but she was released. They had a material witness bond and she was released upon that. Mr. Mason recounted at the hearing, and the trial court found that he had twice subpoenaed a witness to be there, who, because the 2 years that had passed in between, would have not only lost his memory or was at risk of losing memories, but had been subpoenaed twice and didn't even know if the person was going to show, alleged victim was going to show up again. So you've got this person that he's continually having to get to court and probably continually being charged on his circuit court file a subpoena fee to tell his side of the story, or to tell an alternate side of the story, or make a case against this alleged victim. And he's not been able to do that because they cannot, like the state, the longer the case gets away from the offense state, the less interest becomes, until finally he couldn't find his witness anymore. As the trial court found, it had repeatedly told the state, like, this is serious, this witness needs to be here. They give 3 different opportunities for that.
But I mean,
and
it seems like from the record, the state did everything it could to try to make sure that witness was there.
I disagree, I think, respectfully. I think having a bonding agent who had somebody who had some skin in the game, I know they didn't want her to be incarcerated as a witness, but somebody needed to be keeping track on her other than the state, and it needed to be not just the state. There are repeated references that the state makes to calling the daughter of the alleged victim and getting information
But once
through
they
her.
got her in, I mean, they had her reporting to the court and to them every week. I mean, that seems like they're doing everything they can possibly do to secure her presence. And then 2 weeks before trial, as Judge Ayers points out, which is not really a whole lot of time before trial for something to go crazy or wrong, yet she doesn't show, or they lose contact with her.
That's true, and the state does make a note that they thought another case was going to go, so they may not have been prepared to have her summoned on that date. But the fact remains that she's, as early as September and maybe even June, when they said that she had been dodging their subpoena, indicated that they had a witness that they were going to have a real problem trying to find. And at every venture they gave her, she abused their trust. Now, Whether or not that's negligence or bureaucratic indifference will be what this court has to decide in terms of looking at what the trial court decided and whether the facts bear that out to the law. But the fact of the matter is we have a person who lost 20 months of his life incarcerated for a person who did not want to show, and who the state did not really make any kind of acquiescence to null pros or preserve the ability to re-indict the case until the trial court kind of caught it with its pants down. If the court doesn't have any other questions on this kind of a...
What was the date when you said the defendant offered the null pros and the state said no?
It was at the January 22nd, 2024 hearing. It would be volume 3. I think the state declined, and the trial court told. That's when.
So 5 months prior
Yes.
to when they actually moved for
Right.
it.
And the state should have been on notice when the trial court told them to file a speedy trial notice that the remedy for a speedy trial violation is dismissal with prejudice.
And wasn't it at that point they sought to get the material witness bond and?
I don't know. They had a material witness bond. She was released on recognizance. I think there was an order releasing her from the material witness bond after the appeal was filed, so that she wouldn't be held during, I guess, the pendency of this appeal while it was being decided. But,
Thank you.
thank you.
Briefly, Your Honors, just to address the record issue, I want to talk about first kind of the structure and composition of the record and then the actual exhibit themselves. The structure of the record is, yes, there is a separate volume that is labeled exhibits, but when you look at it, it's clear that in the technical record there are these filings that are filed in the trial court. It's a notice of intent to use evidence filed under Rule of Criminal Procedure 12, and then a motion to reconsider filed after the dismissal. Those motions refer to exhibits, which are not filed with them, but instead they appear to be these exhibits in this separate exhibit volume. And the numbers of those exhibits correspond with the numbered exhibits referenced in the filings.
Well, what about, are there transcripts that say no exhibits filed?
There are transcripts. There were no exhibits filed at these hearings. I cannot.
So where did these exhibits?
My
At what point did they get entered into the record?
My understanding is they are the exhibits to these pleadings that were filed in the trial court. Now, why they are bound separately, I cannot tell you. I do not know.
Or dated, stamp dated before they were notarized?
That I am not as familiar with, but because they did not go to the subject or the substance of the speedy trial motion that we're arguing here today.
That was gonna be
really
my question.
What is it? What is the impact of those?
There is none, because and I want to clarify some confusion. The motion to reconsider, which is what the defendant appears to be challenging, is not the exhibits that they take issue with those notaries, or the date issues. The exhibits to the motion to reconsider are minutes from the trial court or the court's notes and a transcript of a hearing, which is she has taken no issue with here today. The medical records, the photographs, the affidavits, those appear to have been filed as exhibits to the state's notice of intent to use evidence, which was filed under Rule 12. They are not relevant to the speedy trial motion here today. If there are issues with the dates about the notary versus the dates that these are filed, those might be reasons to attack the weight of that evidence or the credibility of that evidence if this ever goes to trial. But it's not relevant to the speedy trial issue before this court today. And they are all properly included in the record because they are pleadings and exhibits to those pleadings filed with the trial court. These are not discovery materials. It is a notice filed under Rule 12 and a motion to reconsider that under Rule 24 requires that any paper filed with the trial court, excluding subpoenas and discovery and jury list briefs and minutes, are properly includable in the record, and they are properly included here.
General, what does the record show the state did specifically between January 22nd, 24 and May 13th of 2024?
I believe the record is relatively silent about the state's efforts during that time period. They say that they have been trying to contact this witness and they have been unable to. I apologize, Your Honor, I can't remember if it says specifically they called her daughter during that time, but that was their main point of contact. But in that time period was when they did come back in May 2024 to agree to nolly this case, and the court disallowed that resolution. So unless there are any further questions, we ask you reverse the judgment of the trial court.
Thank you. Thank you both. I think with that, we're in recess till this afternoon.
All rise.